Okay, I just want to demonstrate a reasonable lower bound on First Amendment right damages. Um, Now, there are other uses as well. There's cruel and unusual punishment, which is relatively easy to show and has been ruled upon in the case of Adam Weimold here. It was circumstantial for that as an applied case. And the ACLU took up the case of Adam Weimold. And the judge, I didn't read, there's over 1,000 pages of transcripts, so I don't know exactly why no references in the final opinion. No references made to a facial challenge. This reminds me of the Denver cruel and unusual punishment law, which is currently making its way up the courts system. The last case, Salerno was thrown by the judge at the homeless person. Personally, I don't think, well, never mind. I'll keep my opinion myself about that case. But, Salerno can be met. There's a Professor Fallon who talks about separability, which is the presumption of severability. And this law trivially meets that, so it can be severed into sections. And there should be no problem showing that in all possible applications, and not that in Salerno, the Supreme Court doesn't say any theoretical or feasible application, but only all applications, meaning it should be interpreted as extant applications, which is beyond anyone's ability to really to actually look at, unless you're the city and you actually have access to all the extant applications or cases that are going on right now. But okay, that's beyond the point here. So I'll have another tape about Salerno. Although due process is a way around that, because all the tiers of scrutiny, which will be strict scrutiny in this case, because unlike that Hawaiian homeless dude who messed up his case, which having to do with sleep, I have all sorts of arguments that certain fundamental human rights have been violated by this law, and sleep is a fundamental human right. It hasn't been ruled as such, but it comes trivially under bodily integrity. And there are articles out there which says that the integrity of your brain cells actually deteriorate over time. Sleep is necessary to live. The world record used to be 14 days and 3 hours. 2 Chinese gentlemen in their 20s died after 14 days. There's studies on rats which show that they die after 2 to 3 weeks of complete sleep deprivation. So people die without sleep. So sleep is necessary for bodily integrity, for maintaining bodily integrity. And bodily integrity is a fundamental human right. So this law makes it illegal to sleep simply because the final clause, which I didn't even mention before because it's irrelevant, which is camping shall not include incidental napping and picnicking. The word incidental here, incidental napping, really just doesn't make, it adds nothing to it, because it has to do with if one falls asleep incidentally, with no bearing whatsoever, the word incidental, no word to attach to, with the exception of picnicking, perhaps, that somebody fell asleep accidentally after picnicking. What does incidental mean? It must mean incidental to will, intent, right, or mens rea. So if one falls asleep incidentally, that means they fell asleep after being exhausted. They couldn't help themselves but fall asleep. They had no intent to fall asleep. So if they have no intent to sleep, then it has no, and they fall asleep, they had no mens rea. The mens rea element wasn't there. And so I'm just arguing that final clause is irrelevant. The law simply makes it illegal to sleep. All right. And anyway, um, anywhere in Fort Collins, right? Public property, private property, as mentioned before, private property, homeless people don't have the right to be in private property. They don't have, that's not their right. That's the right of people who own private property to invite or to guest or to host homeless people on that property. So, okay, I'm just sort of rambling, but so where now could be met, but due process is the way to go, because there's as Professor Fallon mentions in many of his papers, he has 3 main papers out there. Due process meets facial challenges. Facial challenges are generally met by Salerno, by due process, by overbreadth. We could do overbreadth too because of the First Amendment violation. There's several other ways that they could be met. And also, Fallon's study, which he did roughly 10 years ago, changed the Supreme Court's attitude upon how often it actually analyzes cases on the basis of facial challenges. Facial challenges are the most common kinds of challenges that are not rare at all. And the way that the Supreme Court analyzes facial challenges there is no consistent way that they analyze facial challenges. Facial challenges are analyzed on a case-by-case basis, and there is no one general rule or even a finite number of set methods or algorithms that they seem to adhere to. Okay, obviously there's a finite number that have occurred in the past, so I can't really conclude that. But okay, getting back to the purpose of this tape, which is what is a reasonable lower bound for just my First Amendment rights being violated? Okay, well, we could come up with a number because the condition, how do I meet the condition? My car was not running, it was dead. So the condition of needing to leave the city each night. Well, fortunately, there was a way for me to leave the city each night, and that's to ride bus number 8 or 81. Because if you look at maps, the northern edge of Fort Collins occurs at Willocks, and that bus goes through College and Willocks, and it actually passes outside the city each night. So the cost of riding the bus is roughly $2. I was homeless for 3 years, which is roughly 1,000 days. So that's roughly $2,000. And if you multiply by 10, right, that's $20,000. So I'm saying that the lower limit, the lower bounds for First Amendment violation should be the order of magnitude of $20,000 to ask for the city. All right, that's my end. That's one way to come up with a number. Oh, have a good day.